Okay, you warned me on the phone that we have a big foreclosure crisis coming, and this is going to be worse than Lehman Brothers, possibly worse than 1929. And this is because we've had a many weeks lockdown. People don't have their incomes. They don't have their way of supporting their families now. And we're going to see more than ever. And I think this is absolutely true because this is a global lockdown. It's not just U.S. It's so pervasive that we're going to have millions of people who don't have a way to pay their mortgage, pay their rent, pay their credit cards. So that's kind of what you're aiming at here, right? Is how to help these people that are going to come through like a tidal wave, losing their home.
It's a little bit more than that. So it's not just that they won't be able to afford the regular monthly payment, but they've been given a 3-month moratorium on making payments. At some point, they're going to have to catch those payments up. They're not being added onto the back of the mortgage, which would be better for them. Instead, they're going to have so much time to catch up on those.
And they have no way to do that.
Well, and plus that's if their job is even available, after all this is over. So we're looking at maybe some pretty bad foreclosures coming up in the next 6 to 18 months.
So people who are under foreclosure or in those kind of pressures usually walk in, even if they manage to get into court, they just get manhandled.
It's going to be worse than that.
but you have have an answer to that.
Yeah, but let's look at that for a second, because the courts have also been closed. So what was already a fast-tracked process is going to be even more, speedily taken care of. That, we're expecting some pretty bad violations when they kick back up. So.
Right.
And we do have an answer to that, and I'm going to have Richard tell you about that.
Right. So so it sounds like, well, you're coming up with an answer for this crisis of the moment, but actually you guys, both of you, have been doing this for years. Mm-hmm. I mean, you have been helping people with these legal things for many years. So you're like, oh, we're in the perfect position to deal with this looming foreclosure crisis.
Yes. I got involved in this back in, I think it was 2010. And I met Jackie right around maybe a couple years after that, and she was giving classes and helping people working with foreclosures. And what I did was I cut my teeth by going in and out of the courts like that, and I found out that the courts were run under a statutory scheme, okay? And we decided to join force with each other because we found that people going to the courtroom, they didn't have the wherewithal or the knowledge to be able to confront the courts or to be able to present their case in court. And so what they would do is they would hire an attorney, basically the same thing. They didn't really understand the statutory schemes either, and they would end up getting kicked out of their houses.
Yeah, so when you say statutory scheme, that's kind of like the little secret process the court adheres to the letter, but they don't tell you what that is. And you come in, like you said, maybe with common law or with constitutional law or with this other idea, and they go, that's not what we do here.
Exactly.
Yeah, a little bit more than that too, because they come in thinking they're looking at the foreclosure, they're finding errors in the foreclosure process, but by the time they get to court, they're in an unlawful detainer. It has nothing to do with the actual foreclosure that's already taken part. So that's a problem.
So it has nothing to do with that. So what is it?
Well, see, in 1929, what happened was the banksters and legislation came together, and they amended and changed the statutes to allow to bring homeowners and purchasers into the unlawful detainer, which is a fast track to get the people out of the house. Here in the state of California, we have what they call a non-judicial and a judicial state, but the banks opt to use the non-judicial because they can get you in and out of the property within 60 to 90 days, okay? Right. And what they did was, when they created that statutory scheme, that means that they had to adhere to that. The banksters had to adhere to that. They structured it under 2924, California Civil Code 2924 in all, okay? And you had to follow that statutory scheme to be able to get your remedy at the end in the UD courtrooms.
Right. So this is a real kind of coded, secret kind of thing that nobody out here, and we're working in our jobs, we're in construction, we're whatever, and these guys who are running this scheme in the courtroom have been doing this for decades. They know it backwards and forwards, and we go in there and we're like lambs to the slaughter.
Yeah.
Exactly.
Yeah.
Because
it's fast-tracked.
Yeah, you have these people, the lay people, which could be a housewife, a gardener, a mechanic. They have absolutely no knowledge of the law, and
right.
they have no knowledge of what's being taking place inside the courtroom.
Right.
Okay,
right.
You're going up against a judge who has like 30 to 40 years of law, and he's heard every case that you can think of for all those times that he's in the courtroom Monday through Friday. And then you're up against an attorney who has like 20, 30 years of law, right. And you're dealing against him, and it's not an equal playing field. you're coming in there and you're caught like a deer in the headlights. You don't know what to do.
And they have their little game, and the lawyer, the government's lawyer knows the game, the judge knows the game, everybody knows the game except you, and you don't even know what to argue or what it is. But you were talking about the importance of objection. And if you go in there and you think that they're going to give you justice and they're going to help you and they're going to protect you, that's wrong. You have to actually intervene in their scheme with this objection. Explain the objection idea.
In David versus Goliath, one of the things we focus on is educating the pro se litigant to know when to object, and not just object, but when to pull the judge or the opposing attorney into order. We're going to give them the tools that they need in order to be able to control the courtroom and do well in the courtroom. So that's the idea of it. Yeah.
Right. So you have to be actually prepared mentally to come in there and actually, to some extent, control the
trained.
procedure.
Yeah, we're doing training. Yeah, it's we're training gladiators.
Exactly.
Right.
Yeah.
Right. Okay. So what else do we need to know about, as far as what you actually are going to help people do or learn? How does this work? Is there you said there was a phone call every so often, or how does it work?
Every Monday we have a phone call where we go over the different issues in there. See, because the non-judicial foreclosure is called a creature of statute, and it's pro value versus quality loan. Every case law that you look at right now, and especially there's a Supreme Court case ruling called Dr. Levo versus Westlake, and in that case law, it's a Supreme Court case, tell you it's a statutory scheme and it has to be strictly adhered to. Right. And this gentleman in that case didn't adhere to the statute, so he didn't get his remedy. But he had to start at the bottom, at the Superior Court. He started there, and then what happened is he lost there. Then he went to the appellate division, and he lost there. And then he went to the Court of Appeals, and he lost there. It wasn't until he went to the Supreme Court where he got his remedy. So everything was reversed back to square one, okay? So that means that everything starts from the deed of trust. Okay, and this is what we do: is we take the people there and we start from the foundational document that is used by the banksters or the attorneys or the title companies to take the control of your property. It's the deed of trust, and we go from the deed of trust all the way to the trustee deed upon sale if the property has been sold.
If it's been sold, yeah.
Yeah. If it hasn't been sold, then we go all the way to the trustee deed upon the notice of trustee sale. Okay. And we look for all the defects. We show the people how to look at their chain of title, find the defects in it, and then apply that before they go to court, and then also when they get into court, how to apply that.
So those defects you're talking about, you can actually stop the whole thing.
We want you to be prepared when you go to court. So we will give you all the tools that you need to be prepared, that when you walk in there, you can effectively stop what's going on, whether it's the foreclosure, the unlawful detainer, or to consolidate, or if you're post foreclosure, you can even go back and reopen up the case.
But when you say stop, that means I get to keep my house.
That's the focus of Richard and I. We not just delaying matters. We want you to be able to keep your home.
When there are defects in all this paperwork process, it's like people think they lose because they're not entitled to win. They lose because they didn't perform process properly.
Right.
They didn't understand this scheme, as you call it.
Exactly.
And so once you know this very secret and coded kind of scheme that the courtroom uses, which you two are more or less experts on, I would say. Is that fair to say?
Been doing it for a while.
Then that's what you convey to your people on your calls and your programs or whatever you're doing.
Workshops.
And you then walk into court saying, okay, I know what's going on here, and I know what you need now, and I know how to present this, and I don't need to argue this nonsense. And it's like, put it before the court.
Hold them to the scheme.
This is your scheme. You have to comply.
You have to comply.
Right.
Yeah. You hold them to 2924, and you hold them to all. There's also the unlawful detainer scheme that also applies, and you have to hold them to that. So that's the plan.
Yeah. See, what we run into right now is there's a lot of people out there working with people and putting their paperwork together and looking for the defects and stuff like that, and then the people go into court and present it to the courtroom. But what happens here is that when you walk into the courtroom, people don't understand courtroom procedures. Right. They don't understand objections. They don't understand evidence code. They don't understand subpoenas.
Discovery.
They don't understand discovery. They don't know how to move the court. You know, these are the things that they need to know when they go into court. And see, the courts are training these attorneys. They have what they call mock courtroom procedures to train these attorneys how to proceed inside the courtroom.
So they get to practice, and we don't.
And we don't. And that's what we want to do too.
Yes.
We want to hold mock trials.
Yeah.
Yes.
So it's this drilling, and it's going over the information, and just finding out the scheme and the process to begin with.
Yeah.
Right.
And then sort of practicing how to deal with. You're going to kind of do probably courtroom role playing where it's devil's advocate and oh, I'm
Yeah.
the judge and I'm telling you this, and how are you going to object to
How
that?
are you gonna object
so,
to that?
So people go into this courtroom not only informed about how the process works, but actually knowing how to act themselves.